On August 21st, the Supreme Court issued a decision in a case involving the American Public Health Association. It was actually researchers, along with the American Public Health Association, the International Union, United Automobile, Aerospace and Agricultural Implement Workers of America, and IBIS Reproductive Health. They sued the NIH. The reason they sued the NIH was because the researchers' grants were canceled, and that was after the president directed the NIH, which is a federal agency, to eliminate research on certain topics that they did not want to study. So this started in February, and if you don't remember, to refresh your memory, a bunch of people got emails that said that their grants no longer aligned with agency priorities, which had already been approved by the NIH. So these people sued the NIH, and then the District Court of Massachusetts actually granted a stay and said that this was extremely capricious of the NIH to cancel these grants. So then the NIH appealed the district court. So then the case went to the Supreme Court. So the Supreme Court issued a decision on the 21st in response to the NIH's application for stay of the district court's decision. And so basically what happened was, according to the Supreme Court, the district court doesn't have the jurisdiction to adjudicate claims on the research-related grants. So they basically said, yeah, it's fine to terminate the grants, but it was a partial victory for the NIH. The Chief Justice of the Supreme Court is Justice Roberts. Then there's also Justice Sotomayor, Justice Kagan, and Justice Jackson. So they would deny the application in full, but then we have Justice Thomas, Justice Alito, Justice Gorsuch, and Justice Kavanaugh would actually grant the application in full. And Justice Barrett concurred in the partial grant of the application for stay. Another part of this decision was related to how the National Institutes of Health does its daily operations, and that's the part that kind of continues in this case under what's called the Administrative Procedure Act. So the Administrative Procedure Act provides different ways for government agencies to create policies, and the goal of the Administrative Procedure Act is to keep these activities of the executive agencies as transparent as possible and include the public as much as possible. So government agencies do things like collect public opinion in a comment period, or publish their notices online and tell people what's happening. And obviously there was no public opinion piece for issuing this rule or whatever from the NIH on DEI grants. It was basically decided by executive order. I don't have a legal background. I'm trying to see if there's anything in here that tells me what will happen with the second part, that the Supreme Court did not side with NIH. What is this first page? It must be the overall summary. And then this page is the opinion of Justice Roberts, the Chief Justice. Chief Justice Roberts agrees with Justice Sotomayor, Justice Kagan, and Justice Jackson. Wow, that was a very short decision. Justice Gorsuch and Justice Kavanaugh. Lower court judges may sometimes disagree with this court's decisions, but they are never free to defy them. So they're laying down the law, literally, and saying that we're the Supreme Court. Our laws, our decisions have the most weight. So the claims against the grant termination should be filed in the U.S. Court of Federal Claims, not in federal district court under the Administrative Procedure Act, or APA. So there's this whole thing now happening with the Administrative Procedure Act. It was passed in the 79th Congress. I think I read that it was in 1946. And so Congress.gov, sometime in the 70s is when it starts being digitized. So we can read through this act. It's only 9 pages. So first we have the definitions. Let's see, who was president? Harry Truman was president in 1946, so that's who passed the Administrative Procedure Act. So they define these terms. So every agency separately states and currently publishes in the Federal Register, which the Federal Register is the official daily publication of the government. That's basically a running tab of everything that's happening. And so in the Federal Register, it has regulations, rules, proposed rules and notices, executive orders, proclamations, other presidential documents. We can read the Federal Register at federalregister.gov. So here's federalregister.gov. So this is everything that's happening in federal agencies. So let's go back to the Administrative Procedure Act. I can highlight, what does this mean? I'm not a lawyer. I'm not sure what this means. So we can actually search the Federal Register. How do we search the Federal Register? DEI, NIH grants. So there was one thing. I don't see anything about DEI and NIH grants. So let's go search for National Institutes of Health, Diversity, Equity, and Inclusion. Oops, more filters. In year 2025, because that's when Donald Trump took office. There's nothing about DEI in the Federal Register. Am I missing something? Unless I'm missing something, I can't find anything about DEI in the Federal Register as related to the National Institutes of Health. I'm not a lawyer, but theoretically that information should be searchable and there. So if someone knows where the DEI information is in the NIH and the Federal Register, comment and let me know. Let's go back to the APA. The General Notice of Proposed Rulemaking shall be published in the Federal Register unless all persons subject thereto are named. Wow. And either personally served or otherwise have actual notice thereof in accordance with law, and shall include a statement of time, place, and nature of public rulemaking proceedings, reference to the authority under which the rule is proposed, and either the terms or substance of the proposed rule or a description of the subjects and issues involved. Except where a notice or hearing is required by statute, this subsection shall not apply to interpretative rules, general statements of policy, rules of agency organization, procedure, or practice, or any situation in which the agency for good cause finds and incorporates the finding and a brief statement of the reasons therefore in the rules issued. Okay, so that's like a whole Supreme Court case in and of itself. I mean, the executive orders are published in the Federal Register, but the agency itself, I didn't find anything in that. Maybe the search function isn't good. Fancy Comment wrote a blog about the executive branch. So here's our blog on the topic, and it was updated last year because of Loper Bright Enterprises v. Raimondo, which we actually wrote another blog about. Our summer intern, Toby, wrote another blog about what Loper Bright means for science. So basically, to scroll down to the part where I talk about this, the executive branch does the enforcement of laws, it advances White House policy priorities, and it implements policy programs. So the bills that are passed by Congress can be long and have hundreds of pages, but it's not possible for Congress to write every single part of the law in the pages of the law. So federal agencies do the actual implementation. And there's two things to distinguish between. There's rules and there's regulations. So regulation that is in the works starts out being called a rule. The agency comes up with a rule, there's a comment period. The Federal Register is actually also the place where you can submit public comments. I find that really interesting because it makes me wonder, is there a case to say that the National Institutes of Health actually did not follow the APA? And to be able to understand this, I think you really need to be a lawyer. The APA does have a whole section about judicial review that says any person suffering legal wrong because of any agency action or adversely affected or aggrieved by such action shall be entitled to judicial review. So that kind of goes back to checks and balances. Are we going to see the Supreme Court make a determination on this? I guess the Supreme Court just decided that that was like a whole other ballgame, because judicial review is actually part of this Administrative Procedure Act. So it establishes procedures for individuals or organizations harmed by the agency's actions to seek review in federal courts, ensuring that the agency complies with the law. The purpose of this is transparency, public participation, accountability, and fairness. So the Chief Justice, Justice Sotomayor, Justice Kagan, and Justice Jackson deny the application in full from the NIH to allow the NIH to cancel all the grants. And Justice Barrett concurs in the partial grant of application for stay. So 1, 2, 3, 4, 5. So that could be like a 5-4 Supreme Court decision about like the role of the APA and the role of the federal government. So that would be really interesting, and it would be great for the people whose grants have been canceled, which there's tons and tons of those stories. You can read all these stories of people who are publicly posting about their NIH grants being terminated. I wonder what happens. I don't know what happens after this. Are they going to actually do another decision about the APA and this? That would be interesting to see. So the District Court of Massachusetts, to recap it again, said that it's capricious to terminate these grants. So then the NIH appealed that decision. So then it went from the District Court to the Supreme Court, and then the Supreme Court said that actually it's partially stayed and partially not. So I'm like, I wonder what happens to the part that's not stayed that relates to the Administrative Procedure Act. So we'll have to keep following the news to see where this goes, because it doesn't sound like this is completely over. Thanks for watching, and see you next time.